Reeve v. Lisle and others 1902. In 1896 the plaintiffs agreed to lend £5,000 to the defendant to be secured by a ship mortgage executed later, requiring that if at any time during the period of 2 years the plaintiffs should elect to enter into partnership with the defendant, they would relieve the defendant of liability for payment of the mortgage money, and would transfer the ship, free of the mortgage, so that it could form part of the capital of the partnership. The plaintiffs did not go into partnership, but nor was the loan repaid. A further mortgage was executed, as additional security, in June 1898. In July they made a further agreement, which, after referring to the existing mortgages, the fact that the monies were outstanding and a request from the defendant for further time for payment, gave the plaintiffs a right for 5 years to enter into partnership with the defendant, in which case the same consequences would follow as had been agreed in the April 1896 agreement. In February 1900 the plaintiffs sought to exercise the right to enter into partnership with the defendant. The defendant resisted, on the basis that the right granted by the July 1898 agreement was in the nature of a clog on the right to redeem the mortgage made in June of that year. The House was asked whether the mortgage of June 1898 and the agreement of July 1898 were, in reality, one and the same transaction. It said no. The parties to a mortgage may, by a separate, independent transaction, validly agree to give the mortgagee an option over the mortgaged property, and thus may have the effect of depriving the mortgager of his right to redeem